Hello friends, myself Divyanshu Sharma and I am a second year student of MIT Law University, Gwalior, Madhya Pradesh. And in present I am working with as a legal intern with the LEXIS and Company. And my today's topic is insanity. And now I am going to introduce my topic. Insanity as a defense in India remains an unsolved problem in criminal jurisprudence. However, it presents some fascinating problem that deserves careful analysis. Therefore, there are a few studies on the exploration of the clinical picture of the patient in prison in a 2011 forensic psychiatry study in which 5,024 prisoners were evacuated in the semi-structured interview program that showed that 4,002 people could be diagnosed as a disease diagnosis, mental or substantial use. The physics, the philosophical basis for the exemption of crazy transactions from a form of criminal responsibilities, perhaps the functional limitation of retributive and dissociative theories of punishment that highlight the provision of Section 84 of the Indian Criminal Code that is based on Mcnaughton's 1843 rule in England. Now we will study the Mcnaughton Rule. Norton's rule. There have been several tests for time to time, like the wild beast test, instant delusion test, etc. But the most important, the right and wrong test, formulated in M. Norton's case. The hearing of M. Norton and his release was the topic of discussion in the House of Lords, and as a consequence, that called upon 15 judges to decide on the question criminal liability in the case where the accused is incapable of understanding the nature of act and also answered the question advanced 14 judges at the same answer. The view of the majority was given by Tyndall CJ. These answers to question are known as Mcnaughton's rules. The following principles are cited. First, if the principal only knew what he was doing, or was only under a partial delusion, that he is punishable. Second, there is an assumption that every man is prudent or sane and knows that what he is doing and responsible for the same. Third, to establish the defense based on the insanity, it must be ascertained at the time of perpetrating the act the accused was in such a state of mind as was unable to know the nature of act committed by him. And a person, fourth, the person is sufficient medical knowledge or in a medical man and is familiar with the defense of insanity, cannot be asked to give his opinion because it is for the injury to determine and decide upon the question. English law on the defense of insanity. So we will study according to the English law first. Criminal English law considers insanity a valid defense of crime. The fundamental definition of insanity is based on M. Norton rule. These rules are not about insanity medical definition. The judges declared the following insanity principle. First, all are presumed to be sane and to have enough reason until proved contrary to be responsible for their crimes. It must be clearly demonstrated in order to establish the defense of the insanity that at the time of the act the accused was working under such a defect of reason from mental illness as he didn't know the nature and the qualities of the act he was doing, or he did not know what he was doing was wrong. Now we will study the insanity according to the Hindu law. In Indian law, insanity is provided in accordance with the Section 84 of the Indian Penal Code as a defense under the Indian law. However, the term insanity is not used under this provision. The Indian Penal Code uses the sentence mental soundness. Mental soundness. Mental soundness. In Indian Penal Code, the word mental soundness is used, which means mental insanity. In accordance with the code, the defense of insanity, or that can be called defense of mental insanity, comes from Mcnaughton Rule. In Section 84 of the Indian Penal Code, a person of unsound mind shall act nothing in currently unable to know the nature of the act, or does what is wrong contrary to the legislation due to the lack of sound mind. For this defense, the following elements are to be established. The accused was in the state of unsoundness of mind at the time of this act. Second, he was unable to know the nature of the act or to do what the either wrong or contrary to law. The term wrong is different from the term contrary to the law. So we have covered everything about the insanity in our lecture, and I hope that you liked my video, and I will request you the one thing that if you like the video, so don't forget to subscribe the channel and press the bell icon, and thank you, and have a nice day.